We really encourage you to download a free copy of our 25-point self-assessment checklist, because you want to make sure that you're not violating any types of rules or regulations that can bring you into the crosshairs of government. If you're already in the crosshairs of government, you want to make sure that you're learning every step going forward. And that's why we've created this 25-point plan to help you. You can do your own self-assessment. It's going to ask you to score yourself on one of 4 points. All 25 models gives you a total of 100 points. We want to know how you scored yourself. If you didn't score a 90 or above, then maybe it's time for you to do a little bit more due diligence in figuring out, how am I going to protect myself against this onslaught of government investigations and charges for white-collar crimes. In the first video, we spoke about how government investigations begin. The second, we spoke about subjects, targets, and witnesses to government investigations. In the third, we spoke about subpoenas and search warrants. Now in this fourth one, we're going to talk a little bit about standards of proof and civil proceedings. Now, civil proceedings are no joke, because it's much easier for government investigators to make a finding of fact. These findings of facts can lead to injunctions, they can lead to disgorgement proceedings, they can eventually lead to charges for white-collar crime. So it's really important that we learn about civil proceedings and not think that we're out of the woodwork or out of the trouble, out of the woods, I should say, or out of trouble if we've been charged with a civil investigation. Many civil investigations escalate and turn into criminal prosecutions. So what can we do to understand the playing field and understand what do authorities have to prove? We can then begin thinking about mitigation strategies that might help us avoid the indignity of a criminal prosecution, or strategies that may minimize our downward exposure or our vulnerability to the pain that comes with a government investigation. So with criminal proceedings, I should say, a little easier to describe it that way, prosecutors are the only ones that can bring a criminal proceeding, and that's from the Department of Justice or the State Attorney General's office or the District Attorney's office. But those criminal proceedings, in order to get a finding of guilt, there has to be a finding beyond a reasonable doubt. And it has to be, a unanimous verdict. So either the individual has to plead guilty, or a jury, a petite jury, has to find beyond a reasonable doubt, all members of the jury have to find beyond a reasonable doubt that a crime was committed. With a civil proceeding, on the other hand, it's a different standard of proof. It's much lower. It's called preponderance of the evidence in most cases. And a preponderance of the evidence basically means it's more likely than not to have occurred. Okay? Beyond a reasonable doubt in criminal proceedings doesn't necessarily mean it's beyond all doubt. As my judge said during my trial, you can have a little doubt and still convict. Okay? That's what my judge told the members of the jury. So when you get that kind of knowledge, it's still pretty high, because you've got to have, this is a beyond a reasonable doubt standard. Did the government prove its case? In a civil proceeding, not nearly as hard, because we just have to say, it probably happened. And this is particularly dangerous for people who, when authorities allege that the individual was willfully blind, they knew or should have known. And an example of that was recently we worked with a nurse who, or I guess it's a healthcare professional, she was an individual who did billing for a medical clinic. And the authorities alleged that she was willfully blind because she was creating the bills. And she either knew that the doctor was violating the law, or she should have known. Either way, there was civil liability attached. In many cases, that civil liability can escalate to criminal liability. So we want you to understand these different concepts so that you can work more effectively with the attorneys that are representing you, and you can make more effective decisions as you move forward. I am Michael Santos, and I do hope that you will subscribe to our channel, that you will like us on Facebook, you will download your free 25-point self-assessment, go through the scores. Do you understand what these concepts mean? learning on a scale of 1, 2, 3, or 4. If you do that for all 25, you're going to get a score of anywhere from a 0 to a 1. I guess you'd have to get 25 because you can only score a 1. So you'll get from 1 to 100 points. If you don't have a 90-point score, then it's time for you to start learning. Visit us at prisonprofessors.com. If you need help, you can get a free consultation from members of our team, our mitigation experts. Our motto is, we did the time so you don't have to.